Hi, everyone. Welcome to our Facebook Live broadcast. I'm Steve Altishan, Director of Client Partnerships here at Pacific Cascade Legal. And today I'm here with our founding attorney, Louis Landerholm, to talk about Pendente Lite orders in Oregon divorce cases. All right, Louis, how you doing today?
Great. How are you, Steve?
I'm doing today good. I really like the two things we're doing today. So the this one especially because we've done orders on temporary orders, we've done orders on emergency orders, and kind of that last little group of them are these things called pendente lite orders. So, kind of before we start in, can you talk a little bit about, you know, what they actually are, not each one, but what it generally is, and at what point during the divorce, can a spouse start to ask for them?
Sure. Yeah, so the Pendente Lite orders are orders that occur in the middle of the larger divorce proceeding or custody proceeding. It can happen in either one. So the point or the things that we look at with new clients when we're filing a new divorce or a new custody case is, do we need to change anything? Do we need to get anything in place so that one parent has, potentially support, or what the parenting plan is going to look like, or, a custody determination, or all of these things that, the law is silent on at the beginning of a case. So, if there are those particular issues that come up, then we file for a hearing. Normally we do this as soon as a case is filed. It doesn't have to be. It can be filed later in a case. But timing wise, at least in Oregon, it generally takes a few months to get in front of a judge. So we want to file it as early as possible so that we can go and talk to the judge and get some of these orders in place that we'll talk about today.
Let's kind of start with the first one, which you hear a lot about spouses talking about how they can't afford the divorce, maybe, or what am I going to do if they stop paying for the stuff? And so maybe talk a little bit about temporary orders that can help a spouse pay for the cost of the divorce or maintain them while the divorce is ongoing.
Sure. In a motion for this hearing, you can ask for what's called suit money, which is money directly used to help finance the other spouse's case so that they can, have pay their legal fees, pay expert fees, that sort of thing. So that's one component that can be asked for in the hearing itself. The other two that can be asked for on a support basis are both child support and temporary spouse support. A lot of times the court will order what's called just a generalized family support and reserve how it's going to be divided or defined later. But those are things that can be asked for and ordered in this hearing.
If you get it, if it's granted, especially something like a suit money, does that money come right away? Or is it something that's resolved at the end of the case?
It depends on what the judge orders. Most of the time, suit money comes right away. There'd be a timeline of, say, pay it within 30 days or pay it within 2 weeks or whatever. So normally that is paid right away. Support would be an ongoing obligation, a monthly obligation. So that one would be, just over time, essentially.
Can you ask for that more than once? Let's say you need some money to pay your attorney right off the bat, but maybe then as it gets more complicated, there could be expert testimony, appraisals. Can you kind of take a second dip in that?
I mean, you can, but practically speaking, there isn't a lot of time to do that. So it would be difficult to get two on the docket in one case just because, you're taking 4 months, and then by the time you get another 4 months, you're at trial most of the time.
So it sounds like it's important then for the client to get really good advice
Yeah.
about, estimating what those costs are going to be right at, at the start before you have to ask.
Yes.
Yeah.
Yeah, because we want to get that hearing filed and on the docket as quickly as possible. Otherwise, we just lose the opportunity to actually get in front of a judge and having any meaningful change as far as support is just the help that spouse needs.
Can you get temporary orders on, how the children are going to be taken care of? What's going to happen to the children while the divorce is proceeding?
Yeah, most of the time, that's one of the big reasons why we file for Pendente Lite hearing is to establish a temporary parenting plan. So that way everybody understands what the schedule is going to look like. Normally, temporary custody is punted to the end of the case so that, because there's not a lot of times that a custody decision has to get made right away. That can change depending on the facts of the case, but most of the time we're dealing with a temporary parenting plan.
Is the safety of the children or the safety of a spouse even something that can be brought up as a temporary order?
So I guess it depends on what's happening, right? The facts would dictate. So if there are restraining orders, and restraining orders would be for abuse, actual abuse, threats of abuse that have occurred. So that's a little bit different. In this case, if there were safety concerns, I guess it depends on what the safety concerns are. But one of the things that can be asked for in Pendente Lite is what's called exclusive use of the home. And so if there's tension, emotions, maybe it doesn't raise to the level of abuse, but there's, a reason to ask the judge to order one of the parents to move out of the home, then that can happen in this hearing itself. So, and that also can occur and be asked for in cases even without kids. So, the spouse, if there's, again, it doesn't necessarily have to be abuse. It could be, emotional abuse. It could be yelling, screaming, just tension in general. That it's available to be asked for in any divorce case or in this hearing.
Let's take a little time here to talk about, because this kind of a case seems to be where I kind of like to have you talk about it. It's the person that maybe is being restrained or denied use of the house. Right? Is there a process that they can use to argue against this, or is this all just in one, you put your motion out and you go?
I mean, I think it depends on the facts. So generally, yes, there are times when it won't be ordered. If like the finances of the parties just don't allow for one parent to move out, or there's a way for them to essentially live separately within the house, and maybe there aren't these other issues. But generally, I think the court feels that it's good for the parties to separate if tensions are high, and so everything can sort of calm down to a certain extent. And so a lot of times there will be an order that somebody moves out of the house if one of the parents is asking for it.
So if I come to you and we talk about this and I say, well, my big fear is that if we have my spouse move out, it's their income that's paying for the mortgage, paying for the lights, paying for all of sort of the household costs. Um, can the Pendente Lite order deal with that?
Yeah, so another thing that can be asked for at the hearing is that any secured debts be paid. So even as part of support or outside of support, mortgages, car payments, things that are secured against pieces of property can be ordered that they continue to get paid. So that's how that part works. So you can definitely still get mortgages paid for. The practical problem is that depends on how much money we're talking about. Is there enough money to pay for the house along with setting up a new household for the parent who has to move out? And so it's an analysis on just the finances overall and what's available for both parties to continue to live.
Can you also have a Pendente Lite order regarding other property? Maybe they own a business, maybe there's a vacation, property, cars. Can a Pendente Lite, or does it normally just not work to cover those during the course of the divorce?
Yeah, I think it just depends on whether we're talking about paying for those or awarding them. Normally you can, kind of get exclusive use of a car or exclusive use like we talked about with the house. It gets kind of, we just have to see what the whole situation and circumstances are about the payment of these things. So it can, we can ask that these things be paid for. Personal property gets a little trickier, whether it will be awarded or not. So it's really a factual analysis that we have to do at the beginning on what we need to ask for, what's going on, factually between the parties. A lot of these things, whether a judge grants them or not, we can get agreement between the parties on. Like say one person wants to get their things out of the house. Well, that's not always something that a judge will order. We can negotiate with the other side, the other attorney, to arrange for that person to get their belongings. So there's ways to kind of negotiate and manage those issues during the case, whether a judge actually orders it or not.
Are some of these temporary orders also used as a strategy? Do you see that happening where, well, if you get the house now, if you get temporary, in the house, maybe, it's going to make you more likely to get it permanently in a division of property? Or is that really not, factored into what a Pendente Lite meeting or order is all about?
So, I mean, again, it depends on the facts. The house specifically is an issue that comes up often, as far as like, the court doesn't necessarily care about the value of the home. The value of the home, if it's marital, it's going to be divided. It's really about if one party wants to be able to buy the other person out and be awarded the home and have that opportunity, then the person who remains in the home typically has a better argument to be made that they should be able to, keep the house, but the other party would still get their half of the equity. So the practical consideration is, can that person refi or come up with the funds to buy the other party out to get their name off the mortgage? That's always a big sticking point with a home, is that the court can't tell the mortgage company what they can and can't do. And so even if the judge awards the home to the other party, it doesn't tell the mortgage company that they have to then turn around and take the other person's name off the mortgage. Right. So, there's that part of it that becomes a practical analysis. But a lot of times, whoever initially stayed in the home and is servicing the mortgage has a stronger argument to be the one who gets to buy the other person out, obviously with the caveat that they have to be able to qualify to do that.
Right. Are there any other types of situations that we haven't talked about yet that could arise, which would, bring about someone wanting to get one of these orders?
Um, I mean, those are the big ones. Trying to think if there's anything else that really comes up, frequently. Your big ones are your parenting plans, your child support. We didn't really get into the child support component by itself. You know, in non-divorce cases where spousal support is not available, then child support can get turned on in a temporary Pendente Lite hearing. So we normally get a parenting plan that gets ordered. We get the incomes of the parties, and then a child support order will flow from that. So, that's definitely something that happens frequently. I would say, yeah, really, these are the big ones. The big ones that we deal with are the support, parenting plan, the exclusive use of the home, payment for secured debts, and kind of working out any property issues that are sort of need to get dealt with right out of the gate. So those are the main issues that drive whether a Pendente Lite makes sense.
You were talking about how, the difficulty in trying to do more than one as you keep going on. Can a Pendente Lite order be modified? Especially I'm thinking like a parenting plan, if something that comes up during the middle of the divorce, can those things be modified, or are they in stone until the final dissolution?
Normally they're in stone. Just again, it doesn't make sense to try to, use the court to modify anything. What we typically will do is just negotiate with the other side if minor changes have to be made. Because like any parenting plan, the parties are free to modify the parenting plan. It's just not enforceable. So, if because this is generally new for the parties. So, if there's an order or if there's an agreement that this is going to be the plan, but then you start to work through that plan, then you quickly learn where the problems are or where the
Right,
deficiencies in the plan. So then on the fly, you can make those changes without necessarily having to get a judge involved.
right. And you've already got
So
some base, so it's actually probably easier to resolve it than to try to get it modified.
yeah, because you're not starting from scratch at that
Yeah.
point. It's generally more mechanical of like drop off pickup times, trading one day for another day because you realize that either the travel time or the work schedule or the school schedule just doesn't coincide the right way. And so it's kind of like what the court wants to see happen most of the time. They want to see the parties be able to communicate and talk about changes. So that's not a bad thing. It's a good thing. It's just it just depends on how we get that done, whether we use a judge to do it or whether we can just negotiate.
Got it. Well, looks like we ran out of our time. Again, great conversation. Thank you for, sitting down to talk about, what Pendente Lite orders are in Oregon divorces, custody cases, and I'm sure there are also legal separations, annulments, and, giving us an idea of what they are, how you get them done, and, you know, when they should be done. So thank you for joining us today.
Yeah, you're welcome.
And everyone else, thank you for joining us. If anyone has any further questions, please feel free to contact our firm. We can get you connected with an attorney who can